There's a very specific sound you never want to hear in a courthouse. It's not a gavel. It's not shouting. It's the quiet, coordinated movement of people who already know what's about to happen. Shoes moving at the same time, doors closing, phones being taken, and this morning that sound echoed through a federal building because U.S. Marshals were deployed on a judge's direct order, and they weren't there to observe. They were there to collect. Let me say this clearly before we go any further. This is not another leak. This is not another delay. This is not another round of lawyers screaming on cable news. This is a federal judge deciding she's done waiting and ordering arrests after listening to something she believes proves serious crimes were committed. That doesn't happen. And when it does, it means something has gone very, very wrong for a lot of people. According to multiple sources inside the courthouse, Judge Eleanor Caldwell signed arrest warrants early this morning after reviewing what's now being called the Witness 14 tape, 47 minutes of recorded testimony that was never meant to be public, 47 minutes that someone thought would stay sealed forever, and 47 minutes that once they leaked, apparently convinced a sitting federal judge that immediate action was required. Here's the part that should make everyone sit up straight. Judge Caldwell didn't schedule a hearing. She didn't ask for briefing. She didn't take it under advisement. She verified the tape, watched it in full, consulted with her clerks, and within 6 hours authorized custody orders. Former federal prosecutors are calling that virtually unheard of in modern practice. Judges don't move that fast unless they believe delay itself is dangerous. And now marshals are on the ground. The chaos inside the courthouse this morning was real. Phones confiscated, attorneys pulled into side rooms, exits staffed, no press allowed anywhere near the proceedings. People who've covered federal courts for decades described it as the tensest atmosphere they've ever seen outside of terrorism cases. This wasn't theater. This was containment. So what is on this tape that triggered a reaction like that? According to verified transcripts circulating among journalists and legal experts, Witness 14 describes a coordinated effort to obstruct justice, tamper with evidence, and intimidate other witnesses while an active federal investigation was underway. Not vague allegations, not impressions. Specifics, dates, names, locations, payments. The witness reportedly describes being told exactly what to say under oath, given a script, told who else was cooperating and what their testimony needed to align with. And when they hesitated, when they asked what would happen if they didn't play along, they were warned their family would face consequences. That's not coaching. That's felony witness tampering. The tape allegedly goes further. It describes meetings where evidence destruction was openly discussed, documents shredded, hard drives degaussed, cloud backups deleted, all after subpoenas had already been issued. That's not negligence. That's obstruction. And according to people who've heard the audio, the level of detail is chilling. Badge numbers, banking information, physical descriptions of rooms, direct quotes from conversations, and then there's the part that reportedly pushed this over the edge. The threats. The witness describes receiving photographs of their children's school, not a threat spelled out in words, just images, with a message that read, "Testimony has consequences." If that's accurate, it elevates everything. Threatening a witness is one thing. Threatening their kids is another category entirely. Prosecutors treat that as a severe aggravating factor, and judges do too. Judge Caldwell reportedly listened to the tape twice, not once, twice, stopping only to ask clerks to pull relevant statutes. When she took the bench in the emergency session, people in the room said her demeanor was unlike anything they'd seen from her in 22 years on the bench. Calm, controlled, furious. She reportedly said she had never encountered evidence of witness intimidation this explicit or this organized, and that the conduct described represented a direct assault on the authority of the court. Then she read the names, 4 of them. Arrest warrants signed and sealed. At that point, 2 defense attorneys immediately tried to withdraw from the case. The judge denied both motions on the spot, and then she delivered what may end up being the most chilling line of the morning. Anyone who knew about these activities and failed to report them should consider their own legal exposure carefully. That's when it became clear this isn't just about defendants, it's about everyone around them. Let's talk about why this moment is so different from every other leak we've seen in the last decade. Leaked tapes aren't new. We've had Watergate. We've had the Access Hollywood tape. We've had countless recordings surface online and blow up reputations. But those tapes either came out before formal charges or after years of litigation. This one landed in the middle of an active federal case involving a protected witness. That changes everything. The judge isn't responding to the leak. She's responding to what the leak revealed. The illegal release of the tape is itself a crime, and she acknowledged that. But she made it very clear the content of the recording describes crimes of a much greater magnitude and urgency. Legal experts are pointing out something important here. Arrest warrants don't require a conviction. They require probable cause. And when a judge believes ongoing criminal conduct is occurring, especially conduct that threatens witnesses or destroys evidence, she has not only the authority, but the obligation to act immediately. That's the key word. Ongoing. This wasn't about punishing past behavior. It was about stopping current behavior before more damage was done. Now here's where this story gets even more serious. The response from the defense. Instead of directly denying the conduct described on the tape, at least one legal team issued a statement attacking the judge, calling the action an abuse of power based on illegally obtained evidence. They focused entirely on the fact that the tape leaked, not on what it contained. Legal analysts have been blunt about this. When your defense is, "You shouldn't have heard this," instead of, "This didn't happen," you're in trouble. No one has publicly denied the meetings. No one has explained the payments. No one has offered an alternative explanation for photographs of a witness's children appearing on someone's phone. Silence can be strategic, but here, it's loud. Behind the scenes, the consequences are already spreading. Bar associations in multiple states are reportedly reviewing whether attorneys named in the tape violated ethical rules. If lawyers facilitated witness coordination or knew about intimidation, disbarment becomes a real possibility. Criminal charges, too. This also puts immense pressure on everyone else connected to the case. Obstruction charges carry heavy sentences. Witness tampering carries heavy sentences. Threats to family members can add years. And if prosecutors can establish coordination among multiple people, racketeering statutes come into play. That's the moment when defendants stop thinking about winning and start thinking about surviving. And let's talk about Witness 14, because they're the center of all of this. According to sources, they've already been moved to a new secure location. Their protection detail doubled, communication restricted. That tells you the court believes the danger is real. Think about the position this person is in. They cooperated, they trusted the system, they entered protection, and someone with access to sealed material leaked their testimony. That betrayal alone is staggering, but what it exposed may have saved their life and the integrity of the case. There's a larger point here that matters to everyone watching this. For years, people have complained that powerful defendants obstruct justice with impunity, delay, intimidation, evidence destruction. And courts move slowly, carefully, politely, until the case collapses under its own weight. Judge Caldwell just sent a different message. She essentially said obstruction itself will not be allowed to succeed. That when a court sees credible evidence that the process is being corrupted in real time, it will intervene immediately. That's a potential turning point. Legal historians are already comparing this to moments when obstruction became the central crime rather than the side issue. Not because the underlying case disappears, but because the act of trying to defeat justice becomes the most serious offense of all. Now, as of this recording, here's where things stand. 2 of the 4 individuals named in the warrants are already in custody. A third was reportedly apprehended near a private airfield with cash and luggage, which prosecutors will almost certainly argue shows flight risk. The 4th remains unaccounted for, and marshals have indicated they may have left the jurisdiction. Initial appearances are scheduled for tomorrow morning. Bail arguments will be fierce. Prosecutors are expected to seek detention without bail, citing threats, obstruction, and attempted flight. Defense teams are scrambling. Some may seek plea discussions sooner rather than later. And make no mistake, if cooperation starts, this case could widen dramatically. That's why this moment matters. Not because of the spectacle, not because of the leak, but because for once, the system didn't blink. A judge saw evidence she believed showed active criminal conduct and said enough. Whether this becomes a template or a one-off depends on what happens next. But today, something rare happened. The machinery of justice moved fast, and it moved decisively. If you want to see how far this goes, stay with this channel. Tomorrow's hearing could crack this case wide open, and if cooperation begins, we may learn that Witness 14 was just the first domino. The marshals are already moving, the courtroom is locked down, and for the people named on those warrants, the clock has officially run out.